Is what is the crop compensation and land composition to be paid for transmission line construction?
Land is a state subject. When land is a state subject, only and only state government can determine what is the compensation to be paid with respect to land. Land is a state subject under Constitution of India. There is a division of power in the Constitution of India. Certain powers are with central government, certain powers are with state government, so certain powers are joint responsibility. So central, for example, central government has 100% power with respect to nuclear energy. State governments have 100% powers with respect to electricity duty and land. And electricity is a joint responsibility of central government and state government. So with respect to land compensation, only and only state governments have all the powers. Okay. अब challenge ये है, what is the problem to the farmer? Farmer has 4 problems. First problem to the farmer is tower base lost. क्योंकि सर ने रविंद्र जी ने पूछा, somebody asked विनील कुमार जी, विनील जी asked with respect to compensation. Okay, so let us understand what is the problem when you are entering a private land to set up your tower base. What is the problem which the farmer faces? First problem of the farmer is tower base lost. I will not be able to use the tower base. Second problem of the farmer is diminution of value of the corridor land. You are also asking me what you are saying. You are saying to me as a farmer that please don't do any construction in the corridor land or right of way land, whatever I have identified. Please, minimum electrical clearance for safety is important. So corridor land mein, the value of my land has decreased. If I go into market and sell it, I will not get the funds which I require, which is the original value. Third problem of the farmer is while you are setting up the tower or doing stringing operation, my crops will be lost. Fourth, if I have fruit bearing trees, you will ask me to cut all the trees, or if I have timber producing trees, you will ask me to cut the trees also. These are the 4 problems of the farmer. And the compensation has to be determined by the state government. So in Madhya Pradesh, when the transmission company approached a collector, he made compensation of 2,000 rupees per tower base. In Punjab, for the same tower base, the collector said, Kapurthala, the collector said 2 crore compensation. 2,000 and 2 crores. Everyone, all the transmission companies approached the government of India, telling them that you have to do something with respect to compensation for setting up tower bases and stringing operation. Government of India said, no, we don't have any powers. All the powers are vested in the state government. So meetings was called of all the state government, asking them what we can do with respect so that investment flows. So the central government told the state governments, if you want investment in transmission and power sector, you have to have certain unified policy across India. So let us have meeting. So a committee was formed. That committee gave its suggestion in 2015. And in 2015, a guidelines was framed. The guideline, what can somebody tell the name of the guidelines? Guidelines for payment of compensation towards damages in regard to right of way for transmission lines 2015. जब ये guidelines का discussion हो रहा था, and secretaries of around 7-8 states and the additional secretary of Ministry of Power was chairperson. This was the committee which was formed. तब एक question आया कि जो tower base में, when you are setting up tower base, in case the person has approval of eminent domain power, if they have eminent domain power approval, when you set up a pole, okay, so same powers are being used, so no compensation is applicable. Logic is that for telegraph line, setting up telegraph line, when you set up poles, no compensation is given to the farmer. It is only easement right. It is not property rights. There is no change in ROR or Khatoni or Sat Bara, any documents. Revenue documents are not changed. Similarly, there is a electricity transmission line. But the counter argument was there. That towers can be of 20 tons. And your pole of, this telegraph pole is already 20 kilos. You cannot compare 20 kilo pole with the 20-ton tower. And the tower base, that base is now nobody can do any farming in that base. But this radius of a pole is only 10 centimeters. So then it was decided there has to be a demarcation line where compensation will be paid. So the demarcation line was made above 33 kVA का जितनी भी line होंगी. So you can say 66 kV and plus. In that case, compensation will be paid. 33 kVs and below, it is left to the state government. So there is no compensation. It depends on the state government whether they want to create some compensation or not. But there is no compensation, there is no policy, there is no rule with respect to that. So 66. So they said for telegraph facility, you can have 33 kVA तक कोई compensation की बात मत करो. Above 66 and above, you talk about compensation. All right. So this guidelines provided for all the compensation. First, it said for tower base, 85% of the market value rate. So whatever is the market rate of the land, 85% will be paid to the farmer as a compensation for the loss of tower base. Second, for right of way, for diminution of land value, 15% of the market value has to be paid as compensation. Third, crop compensation as per market rate. So as many times you destroy crops. So if you have destroyed crops once, you pay compensation once. If you have destroyed crop twice, you pay compensation twice. That's it. And this is applicable for operation and maintenance also. So if you are not destroying the crop, no compensation required. So that is a crop compensation. Fourth, in case there are fruit bearing trees, then what you have to do is 8 years income of fruit bearing trees plus timber will be retained by the owner, landowner or the farmer. This is the scheme which was made in 2015. Now this scheme was game changer actually. It provided a uniformity across India, wherein state governments where it is silent, automatically you can go to the collector and say this is the scheme, this is the guidelines provided by as a policy from the central government. You can ask the district collector to calculate the compensation accordingly. But then in urban areas there was problem. Urban area people were saying that my land is more valuable and I can also not use the land. Now I cannot build my 4-manzil bakan or shopping complex because of this. So another committee was formed and that committee gave its report or guidelines in 2020. The guidelines name is Guidelines for Payment of Compensation in regard to right of way for transmission lines in urban areas 2020. So land value compensation for urban areas was determined as 85% of market value of the tower base lost. Same. Second, diminution of land value for width of ROW corridor, 15% of the market value has to be paid as compensation. Third, now there are no crops. It is urban area. Non-usability allowance, because no construction activity is permitted, will be paid at the rate of 15%. This was the guidelines of 2020. Now one more issue came up. So there was an act which is Land Acquisition Act. Okay. Land Acquisition Act provides that with 13 acts will override Land Acquisition Act. So it is Atomic Energy Act, Damodar Valley Corporation Act and Electricity Act 2003 will override Land Acquisition Act. This was provided in section 105 of Land Acquisition Act 2. Okay, all right. So this was working fine. This was game changer for the compensation. But remember, land under the constitution is a state subject. State had the power to modify, change, or not to apply these guidelines. So 2015 and 2020, both guidelines are persuasive in nature. They are policy. It is not, you cannot say law, but they were game changer. They brought in uniformity across India. So where the states were silent, there it automatically applied. Where states had certain provision, then you apply the provision with reading it with the guidelines also. Okay. But there was a person in Gujarat, chartered accountant. So he had an issue. He represented to Prime Minister office in 2024. So in 2024, he gave a very big representation to the Prime Minister office and he invoked the provisions of Land Acquisition Act. He said in the Land Acquisition Act, which is called Right to Fair Compensation, the full name of the Land Acquisition Act is Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. So he gave a representation that under section 105 of the Land Acquisition Act, 13 acts, they are exempted. And Electricity Act 2003 is also one of the acts. Okay. But the central government had powers to extend the provisions of Land Acquisition Act to electricity matters also, power sector also. So his representation said that the President of India by special order in 2005 has extended the provisions of Land Acquisition Act to power sector also. Hence, the compensation given in the 2015 guidelines and 2020 guidelines are incorrect. They should be as per the Land Acquisition Act. And as per the Land Acquisition Act, what is the provision? Land Acquisition Act says that there is a stages. So, सबसे first stage में what you have to do is you have to calculate circle rate or market rate. You will calculate what is the circle rate. Once you calculate the circle rate, market rate, you will double it, factor. So agar let us assume 1 square feet ka rate is 100 rupees, it will become 200 rupees. Then you have on that 200 rupees, you will pay solatium of 100%. That means 200 will become 400. So his argument was clear to the Prime Minister's office that Land Acquisition Act has been extended to the power sector, and when it has been extended to the power sector, acquisition of land for power sector, then as per the Land Acquisition Act, everything should be applicable. So if the land market value of the land is 100 rupees, it should be taken as 400 rupees. 400 rupees ka 85% for tower base. 400 rupees ka 15% for the corridor land. That was his application. When it was examined by the government of India, and I also said that land acquisition and easement rights are both different. So if you are doing land acquisition, then you have to pay 4 times. But if you are doing easement, if you are taking easement rights, then Land Acquisition Act does not apply. All right. Government of India, after examining it, they said that, okay, keeping in view the welfare of the farmers, let us revise the rates. But then Land Acquisition Act does not apply. Electricity Act overrides Land Acquisition Act in case of one chunk of land which is acquired for setting up solar plant, then it is applicable, it is okay. But for ROW right of way, Land Acquisition Act is not applicable. Unless and until you are acquiring land, means there is a change in record of rights. Now, today what we are discussing, we are not changing the record of rights, we are not transferring the ownership, okay? But then keeping in view the demand of the farmers, Government of India issued another guidelines. These guidelines were issued only 1 month back. And these guidelines are called Guidelines for Payment of Compensation in Regard to Right of Way for Transmission Line 2024. These guidelines provide that the number one, where it is applicable. It is applicable only for 66 kVA and above lines. Okay, no other. It is not for sub-transmission, it is not for distribution lines. Second, calculation rate. So if you have to calculate the compensation, it will be on the basis of circle rate or market rate, whichever is higher. So collector, if he has to determine, or whether you have to determine directly, you will see what is the circle rate, you will see market rate, whatever is the higher, you will take it number one. So this is the determination process. So let us come one by one. For tower base, the 2024 guidelines provide 200% of the land value. So whatever is the land value, uska 200% double will be given compensation for the tower base. That means 85%. Okay. Second, what about right of way corridor? So for right of way corridor, जिसको हम बोलते हैं diminution of land value, it is 30% of land value. And remember, it is now, these new guidelines are common for urban and rural area. There is no distinction between rural and urban areas. Okay. For all areas across India, this common guidelines is there. It is 30% of land value. One question arises, what will be the width of ROW corridor? So width of ROW corridor will be as per the CEA regulation. So CEA has a regulation which is called CEA, Central Electricity Authority Technical Standards for Construction of Electrical Plants and Electrical Lines Regulation 2020. There is a annexure, and as per the annexure, that will be there. Even in the guidelines in the annexure, that length has been provided. All right. And this 30% will cover diminution of land value, whether it is overhead line, whether it is underground line. All right. But sir, you can ask me a question. Sir, you have not covered crop compensation for crops, and you have not covered tree damages. This guidelines is silent with respect to crop compensation and tree damages. It says that the state governments will decide. But because for tree damages, there is a Supreme Court judgment also, and the last guidelines provides 8 years. So for crop compensation and for tree damages, the earlier guidelines is a good way to move forward. These guidelines also provide when to pay. They say upfront payment. So before you start a transmission tower construction, you have to do upfront payment. In fact, these guidelines provide for a 10-step procedure. So in 10-step procedure, you have to do, this is the standard operating procedure for ROW land acquisition, acquisition of easement right. So step one is, I am reading the step one. Step one is identify landowner and issue notice to proceed. Notice to proceed, number one, step one. Step two is collect document. Two important documents is there. One is proof of identity and second is ownership. Third step, verify land records with revenue maps officials of revenue and revenue officials. So whatever information of ownership has been given, it has to be verified with the revenue officials. Step 4, in case of multiple owners, obtain NOC, no objection certificate from all co-owners attested by Sarpanch and revenue officer. So if there is a joint ownership, in that case, you have to take NOC from other co-owners and it has to be attested by Sarpanch and revenue officer. Step 5, measure tower footing corridor area in the presence of landowners and obtain signature of landowners, revenue officials. Step 6, in case of grievance related to land rates, district magistrate to issue orders in land rates. अगर कोई पैसे का issue है, तो district magistrate उसको rates को clear कर देगा. Step 7, district magistrate or authorized executive magistrate to fix compensation Step 8. Compensation payment to include tower footing, corridor surface, working area, access road. It will also include permanent and temporary structures like hutment, house, line shifting, etc. based on assessment. The measurement sheet will be verified by project ROW lead and countersigned by landowner and revenue officials concerned. Step 9 is disbursement of payment. And step 10, final step is collect receipt from the landowner. So 10-step procedure has been provided in 2024 guidelines.